meeting commences at the moment. I just want to take 2 minutes. Je vais prendre 2 minutes pour...
I just want to take a couple of minutes to remind you of a couple of housekeeping items.
The standard, what do you call that? Procedure. Call the meeting to order. Welcome to meeting number 84 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21, 2023, the committee is continuing its study of Bill C-40, an act to amend the Criminal Code to make consequential amendments to other acts and to repeal a regulation. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. Je voudrais vous...
I would like to confirm to you that all of the sound tests have been done for the online participants.
Benefits of the witnesses and the members who are online as well. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. I do want to let you know that I've got 2 cards here. This one says 30 seconds. This one says time is up. I will be as discreet as possible, but due to the timing requirements, I will, if I need to interrupt witnesses or members, I will do so. Now, a reminder, all comments should be addressed through the chairs. For members in the Zoom, if you wish to speak, please raise your hand. For members on Zoom, please use the raise a hand function. Clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. Lastly, please let the operators open and close your microphones. That's a new procedure. I think they must have had some issues for other committees, certainly not this one, but with many microphones on, it could result in a return of sound that can hurt our interpreters. Les tests ont été effectués avec succès.
The tests have been successfully carried out, and before moving on to the panel for the first hour,
items. First, I'm requesting that we adopt a motion and asking somebody to move it for the following. For the deadline on amendments on C-321, and the motion that I'm looking for is that in relation to the clause-by-clause study of Bill C-321 on Thursday, November 30, 2023, the deadline to submit amendments be Tuesday, November 28, 2023 at noon. Can I please have a motion on that respect? Alors, le date est...
The date is the 28th of November at noon, because clause by clause will be November 30th. We've already confirmed that date on our calendar.
Point out a couple of things on that, and that is, I would like to insist on reminding members that all amendments, including sub-amendments on C-321, must be submitted in writing and sent to the committee clerk. Please do not send drafting instructions to the legislative clerk, as they are not the ones who draft amendments. It must be sent to the Legislative Council. So I'm now looking for for somebody to move the amendment that I'm asking need to be moved. Madame Brière, merci beaucoup. Is there anyone?
Thank you, Ms. Brière.
Objection to that? Okay, so moved. The second item is that you would have received by email earlier on today from Mr. Clerk here 2 budgetary items, one on C-321 and one on C-40. I am requesting that someone move that the proposed budgets in the amount of $16,500 for the study of Bill C-321 and the proposed budget in the amount of $19,700 for the study of Bill C-40 be adopted. And again, thank you so much, Mr. Moore. Any objections? Okay, thank you so much. We will now commence with our our first study, and that is on C321. Alors, avec nous aujourd'hui,
C40, Madam Chair, C40.
C40, yes. Yes, C40. Alors, avec nous.
With us today, as an individual, Mr. Simon Roy, Vice Dean and full professor at the University of Sherbrooke, Faculty of Law. Welcome.
Teleconference, two witnesses, Mr. John Curtis, Counsel, United Kingdom Criminal Cases Review Commission, and Jessica Greenwood, Executive Director, Criminal Lawyers Association. So we will commence now with the first round of witnesses, and you each have 6 minutes, please. And I will ask... no, before we do that, each of our witnesses has 5 minutes for opening remarks. Alors, Monsieur Roy, c'est à vous à commencer. Merci.
Mr. Roy, you have the floor. First of all, I thank you for having invited me. It is a very interesting opportunity for me. Generally speaking, my position is that this bill is a good initiative inspired by other countries. I had the opportunity to listen to the first two meetings, and there are issues I won't come back to, but I do draw your attention on 3 points, please. The first is the jury trial. You know that a jury trial is a case of wrongful convictions. Kent Roach is of the same opinion as me. Why? Because people who are racialized or indigenous people, it's difficult to find a jury that is representative of them. And often these are cases that are highly emotional. In a small town, for example, when there's a murder, it's difficult to organize a trial. And it's obviously very difficult to appeal these decisions. Why? Because with a jury trial, there's no written decision. So why the jury decided this way or that, we don't know. And the criteria is beyond a reasonable doubt, but there's no way to challenge that. So that it really gives the opportunity for wrongful convictions or I think we should perhaps amend Section 649 of the Criminal Code. A jury cannot disclose what happened during their deliberations except where there's been obstruction of justice. So perhaps the bill should be able to speak to the jury members about their deliberations, because in the case of a miscarriage of justice, this is a problem. And it could be an idea to allow the commission to question the jury members. The second case of vigilance, the inquiry, the commission that is proposed, they aren't allowed to visit do on-site visits. If they were able to, that would be of interest. But also this idea of being able to limit or bind the witnesses, it might have an effect on the applicants, because the person applying for this might be forced to testify before the commission. And I'm not saying if it's a good or a bad thing, but I just want to say that that's currently a possibility if the bill remains as it is. And that testimony wouldn't necessarily be able to be used in a subsequent trial. But the person might be obliged to testify against co-accused, for example, if people are allowed to remain silent when it's an issue of testifying against co-accused. But with the commission of inquiry that you're proposing, they might be forced to testify. And the last point of vigilance, concerning defense strategy, there's the whole Jacques Delisle case that you're surely aware of, or the Sarson and the Supreme Court in 1996, that decision. In both cases, there were strategic decisions made by the defense. In the case of Mr. Sarson, he decided not to challenge the law. In the case of Mr. Delisle, he decided not to testify. and both came back afterwards saying that they were victims of unfair treatment. In the case of Mr. Sarson, the Supreme Court said that that's a closed case. There's nothing that we can do about it. And in the case of Mr. Delisle, the minister at the time, looked at his application. But I think we have to distinguish these cases from cases of innocence. Someone who has committed some action but is accused of something else might have as a strategic decision, take a strategic decision so to not be caught for the initial accusation. So Mr. Sarson was accused of murder, but he was convicted of manslaughter. So the defense took that decision. But it might be a miscarriage of justice in a sense, but I don't think the same criteria should be applied, which brings me to the power to review the evidence, and that might be in the bill. So one issue was raised earlier. So when there are findings of guilt with miscarriage of justice, there was the Marshall case in Quebec. He had intellectual deficiencies and pled guilty, and we found afterward out that he was not the person who committed the crime. He was found innocent through DNA evidence. So this is particularly important for marginalized groups and Indigenous women. They are often victims of domestic abuse. Thank you very much.
So on the line we have with us Counsel John Curtis. 5 minutes, please.
Good evening, everybody. Very pleased to be with you this evening. To assist you with the important work, thought it would be helpful to set out some background to the UK Commission's role, its structure, our powers, and the work we do within the British criminal justice system. The CCRC, Criminal Cases Review Commission, was established by Parliament in 1997, and we operate under the Criminal Appeal Act 1995. Parliament created us to be independent and in order to find, investigate and refer possible miscarriages of justice to the appeal courts. We've been in existence for 26 years and in that time have looked at over 31,000 cases. In the same period, the Commission has made 826 references to the appeal court. That equates to more than one case every 2 weeks and a historical average of around 31 cases a year. Around 70% of those references, 70, have resulted in those convictions being quashed or occasionally sentences being reduced. We're funded by way of an annual grant from the Ministry of Justice. Since 1997, our annual cash grant, taking account of inflation, is 8.775 million. Last year, our grant was 7.28 million. So currently, we're operating with funding that's 17.17% below the historic average. Each year, we get around 1,145 applications for review. We've seen a marked increase in past years, following a move towards an easy read and online application form. The forecast for this business year is over 1,600 applications, and that's against a prison population in the UK of over 80,000. We don't have any queues or waiting times at the moment, but that position is very hard to sustain. We aim to conclude 85% of our reviews within a 12-month period. Recently, we've been achieving that, but it's becoming more and more challenging. Obviously, the more complex cases do take longer and reviews can run to 1, 2, or even 3 years. We submit an annual report with accounts to Parliament. Operational oversight is by a board chaired by Helen Pitcher, our chairman, and that includes 3 independent non-executive directors. We've around 120 staff at a rate that equates to 101 full-time equivalent employees. We have 11 commissioners to make decisions, and they constitute 4 full-time equivalents. They're paid a day rate. Many, but not all commissioners and casework staff are legally qualified. We believe in a collaborative and multidisciplinary approach, and So the organisation includes people with legal and investigative skills, as well as specialisms in forensic science and financial crime. Parliament gave us a unique range of investigative powers. We can obtain material from any public body or private individual. We can order and direct police investigations where a case is particularly large. And we have some other powers, including the ability to interview jurors under the direction of the court. We can review any criminal case, from the most minor offence to the most serious. We also cover the military courts. We're a body of last resort, so individuals are usually required to have exhausted their appeal rights before they apply to us. But in exceptional cases, we can review a case even where there's been no appeal. That could include a case where there's extreme vulnerability, perhaps through mental health. We can also deal with cases involving deceased persons if applications are made by their next of kin. We can obtain files from the police, courts, prosecution and defence. We often see materials from schools, social care providers, medical records and the security services. We can speak to witnesses, scientists, police officers, judges to understand what's happened before. And we can instruct new tests on exhibits. We're the only body that can do this. We're the only body that can send a case for a second appeal, and references are made on the basis of fresh evidence or new legal argument. I'll wrap up there.
Thank you very much. We now have Madame Greenwood. 5 minutes, please.
Thank you, Madam Chair, Vice Chairs, and members. Thank you for inviting the Criminal Lawyers Association to present to you today. Our organization represents roughly 2,000 defense lawyers across Ontario, with members from all over Canada. We are on the front lines defending accused persons in court daily. More personally, I was raised in small town Ontario, but practice in Toronto. I was called to the bar in 2009, and I've had the unique opportunity to work on wrongful conviction cases. You may be asking, do wrongful convictions really happen in Canada? We have a world-class justice system, yet we know they do. I volunteered as a young lawyer with what was then AIDWIC and now Innocence Canada for over a decade, working on the case of a young Indigenous man convicted of murder. No single case had a greater impact on me or my career. Creating this commission is such an important step for Canada to ensure that no Canadian receives a life sentence who doesn't deserve it. But for Innocence Canada, we wouldn't know about miscarriages of justice, like the cases of Donald Marshall, David Milgaard, or the now discredited evidence of Dr. Charles Smith. Wanting to end wrongful convictions shouldn't be something that divides us along party lines. This should be a uniting goal for all of us. Wrongful convictions are not good for victims, for taxpayers, or more importantly, the public confidence in the justice system. The CLA supports Bill C-40. Meaningful reform is long overdue, and from the CLA's perspective, a robust system of review requires two essential elements: institutional independence and sufficient infrastructure and resources to do this invaluable work. This bill addresses both, but may not go far enough. The CLA respectfully asks the committee to consider 3 additional points. Firstly, with respect to the commissioner and resources, that the commissioner have security and tenure to review unpopular cases. That's not an easy job, and not one that is popular and may run the risk of political interference. And 2, that the commission is staffed with those candidates who are alive to these issues, to the challenges faced by racialized and Indigenous accused persons, those with mental health issues, and most importantly, people who want to do this difficult work. Second, with respect to the test for intervention, the test has always been whether or not this person who's coming to the minister for review could prove factual innocence. That is such a high bar. We applaud that the new reforms allow the Commission to consider cases where factual innocence is not established. This should be the norm, not the exception. The CLA wishes to stress that this is a critically important change given the many barriers faced by the wrongfully convicted, as pointed out by Justices Laforme and Westmoreland-Traore in their report. Third, we ask that the reporting function of the new Commission be enhanced and that we rely on that critical data to continue to improve our justice system. Bill C-40 presently requires that the Commission report to the Minister on an annual basis about the work it has carried out. We ask that the committee consider expanding that reporting to include systemic trends on wrongful convictions and a mechanism to make wide-ranging recommendations to police, prosecutors, and the courts so that we can diligently make use of the data collected to improve the justice system. Bill C-40 may just seem like another piece of legislation, but I can say from my experience, it has the potential to be life-changing for those who are awaiting and deserve review. Our question is, should the test remain unchanged, or is there more we could do to ensure that we protect the most vulnerable in our society and ensure that fairness and justice are delivered to all, given that our system is one that is internationally regarded as the gold standard? I am available to answer any questions you may have, and given the time constraints today, available to conduct a private briefing with anyone who wishes to expand on these points. Thank you again, Madam Chair, for the time.
Thank you very much. We will now begin with our first round of questioning, and each member will have 6 minutes, and I will begin with Mr. Moore.
Thank you, Madam Chair, and thank you to all the witnesses for appearing today on this important study. My question to Mr. Curtis, thank you for appearing and talking about your experience as we consider this next chapter in Canada. Now, a couple things that I think distinguish us from your experience. I'd like your comment on it. Currently, as the previous witness just mentioned, there's a test that a miscarriage of justice likely occurred, and that's something that the minister currently would have to consider with the support of specialized individuals within the Department of Justice. This bill, in addition to creating this new commission, also introduces what could be a much lower threshold of a miscarriage of justice may have occurred. And when I look at that, by definition, a miscarriage of justice may have occurred, that could probably apply to almost any case. So I know in my understanding of your system, but if you could expand on it, is that in order for there to be a miscarriage of justice review, in our case, there's no requirement for new evidence and there's no requirement of a new legal argument, but that is the case in your system. Could you expand on that a bit? Is what is the threshold that would trigger your looking into one of these cases?
Thank you. So our test is there a real possibility that the appeal court would quash the conviction? And our case law tells us that real possibility is below the balance of probabilities. It's less than a 50% chance in that respect, but it has to be real, so it's reasonable rather than fanciful. So we've got some helpful case law and decisions that guide us on that. Our Court of Appeal will quash a conviction if it believes that the conviction may be unsafe, but within the may, again, I think reasonably is implied. It's a reasonable rather than a fanciful one. New evidence and new argument are by far and away the most common basis, but theoretically it would be possible to quash a conviction without new evidence or argument, but it's a theoretical rather than a practical occurrence.
Thank you, sir. And, when we look at different thresholds and what would be applicable, obviously we have one already of our own. We look at the criminal code threshold of beyond a reasonable doubt, the civil code threshold of a balance of probability in civil law, and a real possibility. Your threshold is lower than the balance of probability. But I would suggest it's higher than what's proposed in this legislation in that a miscarriage of justice may have occurred. So could you speak to maybe some case in general terms of when we talk about new evidence, that requirement that's generally applied in your case of new evidence, what would that typically look like? I know you're dealing with thousands of cases, but can you give our committee an example of what that could look like?
So it could be new DNA that's discovered by more sensitive testing than was available years ago. It can be examples of police misconduct where an officer has been discredited in a subsequent investigation. We've had pathology cases where pathologists have overstated the accuracy of time of death. Medical advancements in pediatrics have been some other examples, as well as developments in the law.
Thank you. How much time I have 1 minute, and I'll ask if you could quickly comment your second avenue of a new legal argument. Could you give some examples of what that could look like in a modern context?
Recently, we had clarification from our Supreme Court on the law relating to joint enterprise, when multiple people have been involved in, say, a murder, but it's not possible to say who did what. The Supreme Court clarified that, and we had to look at around 20 years worth of cases to decide whether new legal argument applied there.
Thank you, sir. Thank you to all the witnesses.
Thank you very much, Mr. Moore. I will now ask Madame Brière pour 6 minutes.
Thank you, Madam Chair. Merci beaucoup à tous nos témoins.
Thank you very much to all of our witnesses. Good afternoon, Mr. Roy. Pleasure to have you here today. And I also thank you for having presented your 3 points to monitor. And I'll stop at the second, which is concerning the investigative powers of the Commission. You mentioned that Bill C-40 does not give the power to visit the site. And you think it's a power that they should have. Well, look, is it absolutely necessary? Perhaps not, except that it's a power that is now offered to judges and juries. So a judge that feels it's necessary to do a site visit can order such a thing, and it's the same thing when it's a judge and jury trial. So it can be the case where the Commission perhaps would benefit from visiting the physical site. I can think of a file in Quebec. A car fell down into a dam or into a lock, and we wondered whether it was a murder or not. So visiting the site and seeing what the physical configuration of the site was would allow them to better assess the situation. And as a commission has investigative powers, if a judge has such a right, it would be rather bizarre that a commission with investigative powers would be deprived of that. Thank you. And the other point you raised was the power to compel someone to testify. So for the accused and also for co-accused, you spoke a bit about that. So could you expand on that? Well, currently, this is a power that a normal commission of inquiry would have, like the Charbonneau Commission or others in the country. So you can't refuse to go and testify before such a commission. But the accused has become the person who's the applicant here because they've been found guilty. So in theory, the commission could compel that person to testify before them to know more about it. So I'm not saying if it's a good or a bad thing, but I just want to raise that issue and point out that it's a possibility and wonder if you're comfortable with that or not, because in a criminal trial cannot be forced to testify. They have the right to remain silent. So in a trial such as this, the person's right to remain silent would be perhaps questioned, and it could be challenged. So there is an issue there, at least. Now, in the context of a review, indeed, do you think that this is something that would be important for the commissioner to have that power so that the bill be most effective? Well, look, first of all, I really like the whole system of an inquiry. In the French one, judges have much bigger investigative powers. Would it be good to force the accused to give their version at their request? That's a political decision that isn't up to me. In law, it would certainly give the commission more powers to come to a decision. As drafted, Bill C-40, which includes the current legislative regime, means that the commission can receive applications from people who have pled guilty where the appeals at the provincial level have been exhausted. Do you think the commission should be able to accept applications in exceptional cases where there haven't been appeals? Yes, I think it's an excellent idea, especially for people who pled guilty. I was talking earlier about the Simon Marshall case, but I come back to some other decisions that perhaps involve Indigenous women. You know, with the Lavallée case, where we became familiar with the legitimate defense because she killed her husband because of being abused. So, but it's not illegal because it was legitimate self-defense. And yet, the person might feel personally that they are guilty, and if they don't have proper counsel, they may plead guilty and they may not have the possibility of appealing the decision. So, particularly in cases where the person has pled guilty, I don't think it's the right way of proceeding. And even if there are fewer miscarriages of justice in these kinds of cases, it doesn't mean there are none. And the Marshall case is a really good example. And once again, particularly for vulnerable people and marginalized populations who will perhaps be less likely to appeal. And sometimes it's through a misunderstanding of legal standards. Sometimes a person can feel very guilty, whereas in law, we haven't done anything wrong. And you can look to someone with mental deficiencies. They might not know what to do. Indeed, we know that many wrongful convictions have been corrected, and they often flow from false guilty pleas, and they often come from people who are marginalized. So in an effort to reduce the length of the trial and to ensure that we have better access to representation, should there be a different standard for a person who falsely pled guilty? Well, honestly, I would say yes. Thank you very much. Mr. Fortin. Thank you, Madam Chair. And thank you to all of the witnesses who are with us today by video conference and been present. Thank you for being here in person, Mr. Roy. I would like to congratulate you. You are associated with the university that is the best in Canada, in my opinion. Now, having said that, I'd like to hear you speak to an aspect that was raised by my colleague earlier, Mr. Moore, on the threshold. Formerly, I want to use the right terms here, we said that a miscarriage of justice may have occurred as opposed to probably occurred. So I think may have occurred sounds pretty broad to me, because I think that anyone could say that there may have been an error may have occurred in my case. And so this threshold of balance of probabilities seems more likely to, what we should use. So what do you think about this in terms of miscarriage of justice? Well, it is a good question. But what we have to realize is that the commission is not the entity that makes the decision at the end. They can send it back to the courts. So if the threshold is too low, we will risk sending too many cases back to the courts. And within the courts, it remains beyond a reasonable doubt, remains to be the threshold. So to find someone guilty. So will that result in more acquittals or fewer? It remains to be seen. But the final decision belongs to the courts. Well, clarification, it's not an issue of guilt. If the commission is faced with a great many applications and is dealing with so many, they may potentially feel encumbered by this. So my concern is, if we want to create a commission that is going to correct miscarriages of justice, do we ask them to review all of the decisions that were where there may have occurred? That might result in a huge burden. The caseload would be massive. So I think we need to perhaps say that the threshold should be cases where there probably or what has been an error. So I'm struggling with that. Well, there's certainly going to be a question of volume. If the test is lower, there'll be a greater volume. But there's also an issue of confidence in our institutions. So the courts, such as we have created them, do they allow a higher or a weaker number of miscarriages of justice? I think that our courts are pretty good. But if the commission exists, it should really deal with cases that are more important. So if the test is an error may have occurred, obviously it might challenge the efficiency of our courts, and we might find ourselves dealing with cases that are unlikely to be successful. In the same vein, we also know currently that these kinds of judicial reviews could last from 20 months to 6 years. So now we don't even have a commission, and we're broadening the access that applicants might have to it and saying there may have been an error. So don't we risk increasing this caseload or workload? Already we're dealing with 20 months to 6 years. We will have insane deadlines. Is there not a way where we could put a limit on the amount of time that the commission will have to make a decision? And if so, what would be a reasonable time frame? Well, no one can achieve the impossible. If there's an avalanche of applications, even if they have a maximum length of time in the legislation, they'll not be able to comply with it. So the courts have given us parameters in Jordan, 33 months maximum if it was in something like a murder, and it doesn't apply to appeals, I understand, but it gives us an idea. What I hope is that there will be more resources provided than before. So yes, there'll be more files, but if there are more people who are dealing with these, perhaps that the time frame will be reduced. And the other thing that's not in the bill that in my opinion is important, can someone apply 2, 3, or 4 times? So I apply once, 2 years later I find something else. Am I allowed to put forward a second application? And 2 years after that, can I put forward a third one? So multiple applications might more easily be weeded out because they'll be found to be inadmissible, but there's no maximum number per person that's provided within the legislation now. So it would be up to the commission to decide whether they'll hear it or not. Now, I have 30 seconds left. What is your idea concerning the maximum amount of time that would be taken for a review? Well, look, it depends on the file, on the complexity of it. If it's just a case where one witness lied, it could be a few days. Well, should the Jordan deadlines apply? Well, that should be the model, yes.
Mr. Garrison, please.
Thank you very much, Madam Chair, and thank you to all the witnesses for appearing today. I'd like to start with an issue raised by Ms. Greenwood, and that's the issue of independence. And the original recommendation in the report on the Laforme Commission on miscarriage of justice recommended that the terms for commissioners be not renewable. And you've raised the issue of independence in terms of the term of commissioner. So I just would like to say a bit more on this question, since we seem to have a couple of competing ideas about how to make sure commissioners are independent, one giving them security of tenure and the other limiting their tenure. And so, Ms. Greenwood, maybe you could give us some advice on that.
Thank you, Mr. Garrison, for that question. I did see that recommendation in the report of Justice Laforme. I understand why you may want a diversity of perspectives, and certainly will need someone who has experience in this area to lead such an important initiative. There are pros and cons to both. If you have someone who has the experience and is leading the commission well, to be reappointed. However, this is difficult work and probably deserves to have someone who brings fresh perspective. So I can see the arguments to both, but obviously I defer to Justice Laforme and his recommendation. And I saw that he had recommendations with respect to both the commissioner and having part-time commissioners and rotating appointments, which I think is key to have enough people to do the work, just along the same lines of the questions that were being asked of Mr. Waugh.
Thank you, Ms. Greenwood. You also talked about the importance of having staff that are aware of the issues in miscarriage of justice, in particular as they relate to the most marginalized Canadians. And certainly when we look at the record of the current process, I think that we heard from one of the witnesses that since 2002 there have been 20 reversals, and of those only one was an individual who was black and only one was Indigenous, and I believe all of them were men. And so when we look at the representation in our prison system, those numbers would indicate there's something wrong, because we have far different ratios of representation within those who are convicted. So can you say a bit more about, in terms of who you think needs to be imported, the mix of people to be imported to the commission, so they're sensitive to this issue?
Right. Well, if we look at the makeup of the prison population, we know that Indigenous persons and racialized persons are overrepresented, as well as people with mental health issues. Some of the stats in Ontario say that 3 out of 4 inmates in Ontario have mental health issues. So we know that those who are seeking review, the staff that are going to be doing the review must have some kind of training, whether it's bias training or other kinds of training that allow them to see different perspectives on these issues, because we know that there is inherent bias that infects our justice system. And while all of the initiatives that have been taken to modernize our system and become more aware of implicit bias are to be commended, we're not there yet. We know these things still impact our system. And we know that juries, especially in small communities, are not necessarily representative of the population. So in terms of how we attract those people, that will have to be something to staff the commission in a way that's representative. Will probably require a robust appointment process and asking people to demonstrate their interest and knowledge and education in these issues, so that we can have real perspective and a diversity of perspective, and perhaps there could be a stakeholder committee that leads to this appointment process.
And last question for you, and I'm going to try and squeeze in one to Mr. Curtis, and that's about the question of legal representation during this commission process. And we know that often those who are most likely to have had a miscarriage of justice have the fewest resources to mount things like challenges to that miscarriage of justice. So how do you feel about the way things are set out in the existing bill in terms of providing legal assistance to applicants?
Yes, I read some of the submissions that were made to Justice Laforme and couldn't agree more that legal representation, especially to someone who's marginalized or has mental health issues, is absolutely critical to the success of the application. And we can take Innocence Canada as an example of that. But for Innocence Canada, we wouldn't have had such a well put together record by lawyers and staff to bring these miscarriages of justice to light. So I think that it is really important that we have a robust system for the appointment of counsel.
So I have just 30 seconds. Maybe I could ask Mr. Curtis to say just a little bit more about the application process and the simplification of it that took place in the UK.
Yeah, we moved, sir, from a text-heavy form to a much simpler one. In terms of representation, people often don't know why they were wrongly convicted. They know that they didn't do what they were accused of, but asking them to articulate what went wrong is only really a starting point. And even good lawyers can't necessarily have that answer. So we have to look at things and bring our own skills to bear on the cases. I think we haven't got a huge amount of legally represented people. 15 years ago, 40% of our applicants were legally represented. That's dropped to less than 5% now. We don't think it changes your chance of getting your case referred, but it undoubtedly takes longer to work through a case where somebody isn't represented.
Thank you. Thank you very much. I will now begin our second round. Maybe we'll go 4 minutes, 4 minutes, 2 minutes, and 2 minutes to allow time for the second panel as well. Mr. Brock, please.
Actually, Mr. Van Popta is taking over.
So I believe I'm up next.
Okay, Mr. Van Popta, please.
Sorry. Change the plans. So thank you so much. Thank you to the witnesses for being here. Jessica Greenwood, I have a question for you. You had 3 asks in your submission, and one of them, the second one, I think, dealt with the issue of factual innocence. And I'm reading here in the Laforme Westmoreland's Commission's report on page 36, and I'm quoting here, the Criminal Lawyers Association told us that, quote, the Commission should only accept applications from persons alleging factual innocence and a miscarriage of justice, close quote. Is that your organization's position?
Well, I actually support what you have written in the legislation as proposed. I think at that time when we made the submission, we didn't have the fulsome sort of background and benefit of all the submissions that have been made. So I would amend that to say the legislation as proposed is what we agree is critically important, and we're hoping that this brings a shift from what was required, which was factual innocence, because that presented huge barriers. As you can imagine, those who are wrongly convicted, who are in jail, if they could show factual innocence, they probably would have done that in the first place. So we do really support and hope that this brings an expanded review of potential wrongful convictions, especially where vulnerable persons are involved.
Okay, fair enough. It's fair enough to change your mind after having done some more research and education. I have another quote from that commission. This is on page 103, where you're quoted as saying, the Criminal Lawyers Association and the Federal Provincial Territorial Heads of Prosecution Group all advised limiting the commission to the most serious cases to avoid overburdening it. Is that still your organization's position?
While I agree, those are the most serious cases have the highest penalty, and so it's the client is in the most jeopardy. I don't think the commission should limit it only to the most serious of cases, because there can also be wrongful convictions in less serious cases like attempt murder or other serious offenses, but that don't attract a life sentence. So I don't think we would limit it in that way, but I understand that overburdening a commission is a concern, and there are resource constraints on any commission or agency. We do appreciate that.
I'm going to switch to Mr. Curtis now. Your organization has 25 years of experience, and so what you're telling us today is very valuable and important to us. How does your commission avoid getting overburdened with what I would call faint hope applicants, clogging up your commission's human and financial resources?
97% of our applicants are disappointed in the sense that they receive a turn down from us, but there's no way of knowing that at the outset of the process. It's something we have to deal with.
Of course. Now, could you tell us about the, let's say, early intake filtering process? There must be some process to dispense with some applications very quickly.
Yeah. So we wouldn't look at a case if there were live proceedings. If there was an appeal underway, you have to exhaust that. We will do a triage system, which a screening will be able to size the case. Is it something we could expect to make a couple of inquiries on? Is there a much longer process? So we will size cases, small, medium, and large. You then try to match it with somebody with the investigative skill set and experience to that type of case.
Thank you.
Good, thank you.
Thank you very much. Mr. Housefather, please.
Thank you very much, Madam Chair, and thanks so much to the witnesses for being here. Mr. Curtis, just very quickly on that last point on the screening, you know, when something comes to the court, normally the clerks will look at applications and then write a bench memo. Is there something like that in process to allow you to go through a wider variety of cases and make quick decisions to screen them out right away?
You can make a recommendation, but a commissioner makes the decision on all the cases. So experienced staff will maybe make a recommendation that this does look like a hopeless case, but a commissioner will make that decision. And sometimes we'll disagree.
Perfect. I want to come to another thing. The thing that I think I'm the most worried about in the legislation is the fact that you need to exhaust the appeals process. And I'm very concerned that the defendants we're looking at, Indigenous, Black, marginalized people, are the least likely to have the financial resources and the least likely to have the ability to pay high-value lawyers to give them advice to continue appealing. Can I get the understanding of what in the UK is allowed in terms of the Commission's discretion to circumvent the exhaustion of appeals?
So it would be extreme vulnerability. Social standing could be an issue. Mental health could be an issue. The need to investigate something that you couldn't do by yourself. So if you're looking at surveillance material, the average person isn't going to be able to get access to that. So the need to use our special powers can also be. 1 in 3 of our references is made on the basis of somebody who hasn't used an appeal. So it is a really important discretionary element.
And so can I understand, I assume then that power is given to the Commission under the original base legislation, even the 1995 Act, under which the Commission was. Okay, so would you recommend we copy or look at copying that language or adapting it?
Yes, I think it's an important part of our work, and the miscarriage of justice that we've investigated, referred, and have been quashed by the court are people that haven't exhausted their appeal. So it's in such a large number that it would seem sensible to take that on board in some form.
Thank you, Ms. Greenwood. Mr. Roy, could you just also give me your opinion on that?
I agree completely with Mr. Curtis. I think that having some mechanism for the most vulnerable to be able to be reviewed, possibly because they didn't present well at their trial. They may be doing better now, be on medication, receiving treatment, and have the ability to participate in a way that they weren't able to during their trial. So I do really agree.
Et Monsieur Roy, est-ce que vous êtes d'accord aussi?
And Monsieur Roy, do you agree as well?
And those people are having a hard time enough to just go through the criminal justice system, so we cannot ask them to go all the steps. It's impossible for some of them.
Madam Chair, do I have any time left or am I done?
Seconds.
How much?
30 seconds.
Okay.
28.
Je vais juste terminer en disant que c'était très intéressant.
I just want to wrap up by saying it was very interesting, especially talking about Section 649. When I was chair a few years ago, we did a lot of work on this with this idea to help juries speak to people who had mental health problems. So thank you, Madam Chair. Thank you to you, Mr. Housefather. And now, Mr. Fortin. Thank you, Madam Chair. So you have 2 minutes. Be careful. Mr. Roy, I'm coming back to you. Not that the other witnesses are not important. It's interesting what I've heard. But you spoke earlier that we should perhaps think about expanding the investigative powers of this potential commission and to give them the power to make site visits and also the power to compel certain witnesses to testify. These are all useful questions to me. But what's bothering me is the following. In broadening their investigative powers to that degree, would that not become a situation where they would recreate the trial, which in fact should not be done? The role of the commission is just to decide if a new trial should be carried out. Is that not going too far? Well, that's an interesting question. We asked earlier if we should be limited to looking at new evidence. Well, clearly, if we're looking at evidence that's already been considered, that there's we're doing something over. But if the commission can look at evidence that wasn't presented during the initial procedures, for example, let's say an argument that someone else committed the crime, if that wasn't raised during the first trial, it's relevant that the commission should be able to hear from that witness to see if there's a possibility. But if that person had already been heard at the initial trial, perhaps the commission has less to gain by listening to them or hearing them again. Well, that obviously will contribute to an additional burden, and thank you to the witnesses for being with us today. Thank you very much. Mr. Garrison.
Madam Chair, I'd like to go back to Mr. Curtis where we left off when he said that only 5% of those applicants in the UK Commission were legally represented. And so I guess I'm going to ask you the obvious question, and I'm sure you have studied this. Is there any difference in the success of having those wrongful convictions reversed? Is there any difference between those who had legal representation at the Commission and those who did not?
We don't think so. We think the difference is in the time that the case takes to review rather than the outcome. Once a case gets back to the court will appoint representation for the actual hearing, though.
And of course, that would be the same situation here in Canada. In terms of successful appeals in Britain, have you noticed any difference in the, let's say perhaps the social makeup in Britain, overrepresentation of blacks or those who live in poverty? Have you dealt with this question in the UK Commission?
We haven't. I can't give you any data on that. I'm afraid it might be something we can supply further to this session.
So it's not something the Commission in the UK has been seized with?
There is a definite overrepresentation of certain communities within the prison population. We work on our outreach to try and improve our application intake so that it is representative of the prison population. And we've had some success with that, but it requires a good investment. It's important that the Commission is resourced to do that, to go into prisons and build those relationships with people in prison and trust within the communities. Yeah.
Thank you very much, Mr. Curtis.
Very much to our panelists, both in person and those online. Members will suspend for 2 minutes to allow the next panelists to be set up. My understanding is there will be 1 in person and 2 by video conference. Our second hour, we are now proceeding with our study on Bill C-321. So with us today, we welcome again, à titre personnel, Elizabeth Conférence, professeure associée, School of Social Work, University. Madame Linda canadienne des syndicats d'infirmières et infirmiers,
who is with us from the Canadian Federation of Nurses Unions, and Dana Thompson from the British Columbia Nurses Union, the British Columbia Regional Council member, Northeast Region.
6 minutes each. And Mr. Brock, are you on the list this time? Oh, sorry, before that. Yeah, you each have 5 minutes for your opening remarks. After that, we will commence the questioning. So I will ask Madame Donnelly to please proceed.
I want to thank the committee so much for the invitation. I'm delighted, it seems third time's the charm, to be able to present to you today. My name is Elizabeth Donnelly. I'm an associate professor, but I am here today primarily because I have spent the last decade plus of my life focusing on workforce health issues for paramedics, and I'm currently a co-investigator with Dr. Moz on the Violence Against Paramedicine Research Group. In addition to my research, I have maintained certification as an emergency medical technician for over 20 years, and I have done a significant amount of frontline work. So this is not theoretical work for me. This is very much about the folks that I've worked with and keeping them safe. Because I was initially supposed to testify last month, I just want to very, very briefly reiterate the points that my colleague made about our research, and that it's identified that violence against paramedics is wildly unreported, primarily due to a culture of underreporting and this idea that tolerating violence has become an expected professional competency. These beliefs around violence being unavoidable are changing after the creation of a novel reporting strategy and significant organizational change. Violence reporting is increasing, and our research, while it's still an underreport, has found that paramedics are reporting violence every 18 hours, are assaulted every 46 hours, and are experiencing violence that results in physical harm every 9 days. The issue of violence against paramedics has been a concern for the paramedic community for years. The Paramedic Chiefs of Canada put out a position paper a number of years ago outlining a host of strategies that needed to be operationalized to keep paramedics safe. That included research to better understand the scope of the problem, evidence-informed strategies to keep our paramedics safe on the front line, increasing in public awareness, and most importantly for the folks on this call today, changes in policy and legislation. This has been reinforced in the white paper that they put out on the future of paramedicine in Canada, where violence was specifically identified as a health issue in the paramedic community. And this has also been captured in the report that Mr. Doherty noted, Report 29, which recommends amending the criminal code. The paramedic community is doing their part. Many services have deployed this novel reporting tool. Many of them have agreed to share their data with my research group so that we're going to have a better idea of what's going on. It's a huge concern for our community because we already have significantly high rates of mental health challenges. While the evidence base is still emerging within the Canadian context, it has been identified as a correlate to depression, anxiety, stress, burnout in other populations. And also, not specifically with paramedics, but exposure to violence has been identified as associated with an intent to leave the profession. And right now we're struggling to get providers on the roads. We're struggling to staff the trucks. And so we need to keep every human being that we have to provide the services that Canadians count on. The paramedic community needs you. It needs the justice system for so many different reasons. Because violence was so long considered unavoidable and tolerating it was an expected professional competency, we need everyone to say, no, that's not true. Paramedics are helpers. They show up, they train, they prepare, and they will be there in the night, upside down in a ditch. Like, they will show up for you when you need them. But is it really reasonable that we tell our paramedics that we want you to show up, but we also want you to deal with intimidation and racial slurs and sexual harassment? Would you expect that in your workplace? Would that be acceptable for your constituents? I don't think that that's true. Just legislation alone isn't going to solve this problem. It's complex and it's going to require comprehensive approaches. Paramedic services can do their part by putting programs together to keep their paramedics safe. Police organizations can get involved by investigating and laying charges. The Canadian government can do the part by amending the criminal code. Amending the criminal code will do a lot of different things.
Thank you very much. Thank you very much, Ms. Donnelly. We'll go back to you with questions. Next, I would, Madame Linda Siras.
Bonjour. Sorry, Elizabeth, it's the worst part of the job, that bell. Thank you, Madam Chair, and thank you for the committee member for the invitation. It's a privilege to be here. As you know, I'd like to acknowledge the land that we are sitting on, which is the unceded, unsurrendered territories of the Algonquin Anishinaabe people, and I'm a proud New Brunswicker from the beautiful land of the Mi'kmaq people. But we're here as president of the Canadian Federation of Nurses Union and my 250,000 members, and I'm proud that Danette, one of our leaders in British Columbia, will be presenting soon. We're the working nurses. We're like the paramedics. We're there 24/7. We're there taking care of the sick. Canada's nurses believe in the language in Bill C-321, complements the existing protection and the criminal code change outlined in Bill C-3, which is now 2 years old, and I'll get to this soon. The criminal code change found in Bill C-3, aim to ensure the better safeguard of healthcare workers, including nurses. And now Bill C-321 proposed expanding language to include first responder. We welcome this proposed change to the criminal code. We recognize that violence against any healthcare workers, first responder, in performing their duties is an aggravating factor to sentences. The facts are shocking. You heard Elizabeth talk about the paramedic field. In 2023, a pan-Canadian survey was done on nurses. 2/3 reported incidents of physical assault over the past year. 40% of nurses report physical abuse more than once a month while engaging their duties. All workers deserve workplace free of violence and abuse, and it should not be tolerated. Sadly, nurses and healthcare workers are experiencing it routinely. We have to look at these. We have to bring new measures, such as changing the Criminal Act, but we will also talk about prevention modes. Many people in Canada are aware that public safety personnel, peace officers, police officers, firefighters, correction officers, have a high-risk job, often face violence. Most would be surprised that the same ratios exist in the healthcare field. Our healthcare facilities and our healthcare system is not a safe place to work. In addition to physical injury, workplace violence is strongly correlated with the negative impact on workers' mental health and has seen as an issue facing nurses for many years. Exposure to violence predict negative mental health outcome, including PTSD. From our surveys, working nurses are 3 in 4, so 78.5%, report symptoms of burnout, and similar data are seen to public safety personnel. A similar study was done by CFNU in 2019, and nearly 1 in 4 nurses screened positive for symptoms of PTSD. MP Doherty will remember all the work we did in 2019 on a federal framework on PTSD, and including healthcare workers such as nurses and paramedics. Sadly, violence and abuse is normal in the healthcare system, and such high rate of violence should be unthinkable in any other profession, and it needs to be stopped. The healthcare risks are often accepted. The House of Commons Committee on Health, ESSA, tackled the challenge of the rampant violence against nurses for the first time in a 2019 study. C3 came out of this law in 2021 as one of ESSA's recommendations, and C-321 will expand these protection, and nurses are in solidarity with paramedics on this. But we need to go further than this. We need to be clear that this is not enough. We have to make the public lawmakers aware of the changes in the Criminal Act and work on better protection for our healthcare workforce to work safely into our healthcare facilities and in our community. Thank you so much. While we're encouraged of all this work, we know that there's many more recommendations by the ESSA committee that has to be done. There, we support this piece of legislation, but we encourage all MPs and all committees to look further to make our healthcare and our communities safer for those who take care of the sick and the injured in our work. Thank you, Madam Chair, and I'll answer your questions.
Thank you very much. Next, Madame Thompson, please.
Good afternoon. I'd just like to acknowledge that personally, I live on the unceded territories of the Clay Lake Tenay, where MP Doherty is from, and today I join you from the lands of the Coast Salish people, the Musqueam, Squamish, and Tsleil-Waututh. It is an absolute privilege to be here with you today and to speak on behalf of our members. When you consider acts of violence as a cause for workers from all occupations having to take time away from work, nurses represent 30% of total claims, the second highest occupation behind nurse aides, orderlies, and patient service associates. Between 2018 and 2022, nurses reported an average of 51 injuries per month, acts of violence. That's in BC alone. The number of injuries reported over a 4-year period has risen by 49%, from 1,653 between 2013 and 17 to 2,458. It's unacceptable. BCNU represents approximately 48,000 members here in the province of BC. And you just have to turn on the news to see the increase in aggression in our society. Wait times in healthcare facilities due to circumstances outside of nurses' control are increasing, and incidents of violence are actually increasing along with them. Nurses who are working short, trying to give the best diligent care to their patients, are being targeted. They need to be protected. That is our job, your job, my job. We need to do this today. Their families need them to be able to return home safe. Can you imagine going home and not being able to hold your young child due to being assaulted at work? Can you imagine a patient in a waiting room calling 911, warning them that a healthcare worker is about to get seriously injured, if not die? And then he proceeded to attack one of our male nurses and attempted to choke him out. The nurse attacked was working a shift. His wife was supposed to work. Had he not been there, his month recovery could have looked so much different for somebody else. What about the nurse in rural BC who last January entered a female patient's room and was attacked? Can you imagine being held over a chair, receiving punch after punch after punch, with handfuls of your hair being pulled out, while waiting frantically for help to come by the RCMP? And in many rural communities at night, there's only one RCMP on. That nurse was actually helped to get free by another male patient that assisted. We hear horrifying stories, many that are so horrifying, I can't even tell you. The psychological impacts to our nurses, our nurse victims and their colleagues trying to assist them last far beyond the physical trauma. This is costing the already crumbling healthcare system, as nurses are now dealing with their own mental health injuries and time off work trying to heal. We are losing nurses from our system. This is the first time ever that BC is reporting empty seats in nursing. It's normally a wait list to get into our programs, and we're not even filling our seats. We have an obligation to protect those who are protecting others. We have an obligation to care for the caregivers. And I'm excited to be a part of this today. I thank you for having us here as the BC Nurses Union. I look forward to answering any of your questions, and we fully support Bill C-321.
Thank you very much. We will now begin our round of questioning for 6 minutes each, and we'll start with Mr. Brock.
Thank you, Madam Chair, and thank you, ladies, for your attendance virtually and in person, and for your advocacy in this particular area. So I'm going to turn matters over to you, Ms. Donnelly. Unfortunately, you ran out of time. The 5 minutes does move very fast. So I'll give you an opportunity to finish your thoughts.
Thank you so much. I think that one of the questions that was asked when my colleague was testifying is, what does this matter? Why is this going to change? And it's going to change a ton because it's going to communicate to paramedics that they're valued and that the government of Canada supports them. It's going to raise public awareness and say, hey, this issue of assault against our helpers is unacceptable. It's a serious offense and will be treated as such. It's going to communicate to law enforcement and to the Crown that these assaults aren't just assaults. They are threats to public safety because we're losing our helpers. So when we lose our helpers, we're going to lose safety for our whole community. And then I think the other thing that's really important to understand is that just because the criminal justice system gets involved doesn't necessarily mean everything's going to result in conviction. There are lots of avenues, diversion, mental health court, that can be used to get folks who may have health concerns the right kinds of supports. So the goal of this is restorative justice, not punishment necessarily. So thank you so much for the extra few minutes to get my final thoughts out. I appreciate it.
You're welcome. So the next question can be answered by anyone on the panel. I'd like to make an observation that it's probably no small wonder that we have a crisis in the nursing profession in light of everything that you have shared with us in terms of the historical nature of the profession and the abuse that the profession receives. This is nursing, and this is also first-line responders as well. I understand underreporting is both commonplace in the nursing industry and in paramedic field and first responders. I'm married to a wife. Sorry, I'm married. I do have a wife. I'm married to a nurse. You represent my wife, and for the last 20 years, I have heard example of how she's been personally tormented, that the administration is not doing anything about it, that there's a lack of security within the hospital setting itself. The security is not acting as a deterrent. So the question I'm bringing to your attention right now is the whole issue of public knowledge, information sharing, making sure that the police understand that they have tools available to them to charge. But the concern I have is one on deterrence. And one of the central features of sentencing on any particular case, from shoplifting all the way to murder, is that there's an element of deterrence, personal, specific deterrence to the offender, to learn that there are consequences for your behavior, and general deterrence to the community that if you engage in similar like behavior, these are going to be the consequences. And I'm hearing from all of you that that is the message you want to share. So we now know, and for many, many decades, there have been numerous cases of offenses in the criminal code that have with it, attached to it, aggravating features. That when you commit an offense against a certain individual in certain circumstances, it is an aggravating feature of sentencing. So in light of that, do you have any evidence to suggest that the criminal code actually will have some impact on the community at large and your profession by making this an aggravating feature when you assault a healthcare worker or a first responder? To anyone on the panel, please.
I'll start and thank your wife and give her hope because I do have hope. I've been on many committees on either violence or the shortage, and we do have a crisis in this country. The crisis goes further than nursing, so in all respect to our other healthcare workers. Why it's important to change the Criminal Act, Elizabeth said it. It's a question of respect. It's a question of acknowledging that there's a problem. We know as citizens that if we get stopped by the police and we spit on the police officer, we know exactly where we're going. In healthcare, Patients, community, parents do not understand that. So we have to change the culture. And changing the culture starts by laws, starts by prevention programs, starts by MPs like yourself talking about and saying, this is not okay. In my occupational health and safety experts from Alberta are going to Windsor next week, or the week of the 5th, to look at their metal detectors at the Windsor Hospital. That is discouraging. Discouraging. Healthcare dollars should be going to providing more nurses, more doctors, more healthcare professionals and workers, not for metal detectors, but that's where we're going, and you're going to see it going across the country.
Okay. Anyone else on the panel wish to respond?
Yeah, I would like to respond.
Go ahead quickly.
I just agree with Linda that we need to actually show value to the people that are caring for our members out there and for the public. We need to tell them and show them that this is not okay, that we don't expect them to go to work and be beat up every day.
Thank you. I will now go to Mr. Maloney.
Thank you. I'm going to pick up on what Mr. Brock was asking because I was going to go down the same path. Ms. Sedlis, you said something along the lines, we need to look further, but you talked about prevention versus the criminal code. So I think, and correct me if I'm wrong, I'm just pontificating here a little bit, but if when police are encountering somebody, it's probably they're engaged in a criminal act, but when people are dealing with health professionals like nurses or paramedics or whatever, they may be people who are in circumstances that didn't involve a criminal act or criminal behavior, but they're still the ones who are involved in some of the conduct we're talking about. So I guess my first question is, I mean, we're all in agreement, I think, on this bill, frankly, and I want to thank Mr. Doherty for bringing it forward, and it's further to C3, as you pointed out quite rightly, but is this going to be enough? Because there seems to be a much bigger problem. So I'm not sure that amending the criminal code to say that if you spit on a nurse, as the example you used, is going to act as a deterrent. Like, what else needs to be done? How do we as parliamentarians, what else can we do to create an environment where preventing this type of behavior? Because the numbers I'm hearing are staggering.
I'd go back and read the ESSA report of 2019. The ESSA report on violence in healthcare gave strict recommendation, and prevention was number one. I couldn't have written the report better myself. We have to talk about prevention. We have to talk about a culture change, and it goes from safe staffing to proper occupational health and safety. You know, look at the past pandemic. Healthcare workers had to fight to get the proper PPE. We would have never seen that on a construction zone because we do not look at healthcare as the same thing as any other workforce. That's why we're in a mess today.
Okay, does anybody else have I have a follow-up on that. Does anybody else have a comment on the general proposition? Mr. Doherty, I was hoping you might. For Donnelly, sorry. I'm a graduate of the University of Windsor, by the way, so I'm glad you're here.
Well, I congratulate you on your excellent taste. Well done. I would say that it's not either or. Changing legislation is prevention. There have been a number of examples of success where like at Peel Region, if they're getting multiple violence reports, they can go out and they can reach out to this person and be like, if you continue to do this, these are the possible consequences. If you continue to do this, these are the ways in which may respond. It's creating the legislation changes police attitudes and changes police responses to the violence. It changes the lens with which the Crown looks at these incidences. So it's definitely not an either or. And, you know, when I said before in my comments, this has got to be comprehensive. Changing legislation is a critical piece, but it is just a piece. And those other elements that I had mentioned earlier are still so needed. Thank you.
Okay, thank you. No, and that's where I was going because, I mean, we can amend the criminal code and introduce other legislation at the federal level, but much of what you're talking about falls to the provinces and industry, quite right. So what can we do to encourage better conduct or conduct that's going to help with other levels of government? Because I suspect funding's a big part of this. You talk about PPE during the pandemic. One of the big issues that the healthcare profession faced was a shortage of funding from provincial, I live in Ontario, from provincial governments, and the federal government had to sort of step in and fill that gap. So what should other levels of government be doing to address some of these issues?
To change a culture, every level of governments need to be speaking about it and take it as a priority. And that's what we're seeing now. You know, we talk about hope. Last September, for the first time in history, a police alert went out in Ottawa for a man driving a red truck who had assaulted healthcare workers and nurses in a facility. First time in history. That was a success, the C3. Now we need to go further than that. That's the only one we ever heard. First time in history, a man in New Brunswick went to jail for 2 years for assaulting a nurse. She will never work again. But first time in history, the criminal justice. But that created a ripple effect to cause more prevention, more occupational health and safety methods to prevent violence, from tagging family members, from tagging patients. When I say tagging, just means if they have a past behavior of violence, well, there's special rules that the team needs to know.
I think I'm probably out of time, Madam Chair. Oh, I'm not. Okay, great. All right. So,
I'd like to answer that.
yeah. Okay. Yeah. Please. I was going to ask you to. I thought I had 5 minutes.
We've had some good work happening here in BC, and recently the Ministry of Health has announced that we have 26 relational security officers hired. It's just a new project. We know there's going to be glitches, but these are security officers that are trained, that will be working as part of the team in our high-risk sites, but they need to be everywhere, and they need to be able to actually take down somebody that needs to be taken down, or remove people from facilities that are behaving inappropriately, because that is not a job of a nurse. And oftentimes police take too long to get there. Their slates are full too. That's no judgment. So we're excited about this new program, but it's just such minute. We need so much more to happen.
Thank you very much. We will now go to Monsieur Fortin, s'il vous plaît. 6 minutes.
Merci, Madame.
Thank you, Madam Chair. Thank you to the witnesses for being with us today. It's an important subject, and we'll never have enough information about this. My first question will be to Ms. Donnelly. In 2021, Parliament passed provisions to amend 718.2A of the Criminal Code, and we added subsection 3Is 2. And this regards a person who provides health care, including personal health care, be considered, if attacking such a person, be considered an aggravating factor. So my question to you, Ms. Donnelly, is, has that provision had an impact on the frequency of attacks on people working in healthcare?
I'm afraid I don't have enough familiarity with that legislation and its impact to comment with any sort of specificity. I'm hoping perhaps my colleagues might have some thoughts. I'm very sorry.
I understand. You haven't heard of that provision when it came into effect in 2021?
I haven't seen it being operationalized yet in any of the interactions that I've seen, as far as trying to have charges laid against folks who assault paramedics. But as I mentioned earlier, we have a lot of organizational hurdles, and that is paramedics reporting, that is police feeling like something may warrant charges, it is the Crown deciding to lay charges. So, you know, whether or not that previous legislation has affected it, we still have a lot of work to do around organizational culture.
Merci, Madame.
Thank you, Ms. Donnelly, rather. I'd like to ask, I don't mean any disrespect, but we don't have much time. I'd like to ask the same question of Ms. Silas here. In your work with the Federation of Nurses Unions, have you heard of that particular provision, and did it have an impact? Well, just to clarify, the change you're talking about is one that was made to C3, or through C3? I believe so, yes. Answer, yes. So as I was mentioning, for the first time in history, we had a press release talking about man driving a red truck who had attacked nurses last September in Ottawa, and it's the only time we've ever heard that. What's lacking with C3, and we spoke to the former Minister of Justice about this, is the lack of education. If you speak to a police officer or a lawyer in your area, they don't know this exists. Thank you. Because 718.2A 3 small i's 2.2 is about the same thing as what's being proposed today. So the fact that this aggression be committed against a healthcare worker, including personal healthcare workers, don't you worry that this is something that's already been covered in this bill by the previous change? Or do you think there's some complementarity between the two? Well, for us, it doesn't worry us at all, because we're talking about a group of workers who work separately from most people in the healthcare system, but they've identified a need. And we, as nurses' unions, want to support this change, and we, through this, can protect all healthcare workers. Well, I'm sorry, I agree on that, but the current provision says that a person providing healthcare services, and C321 will cover healthcare professionals or first responders. So we already have someone providing healthcare services, including personal care. So it seems to me to be the same thing in both of these provisions, and that's the one thing I wanted you to speak to. It's the first responder that's the difference. The first responders work in different areas than healthcare providers. That's why we accepted this change. And we had some members. Now I'm trying to say it in French, and I'm stumbling over my words. But I speak French, yes. I hope so, because I come from New Brunswick. But we asked the same question as you, Mr. Fortin. But it was that particular group of healthcare employees who are really different from the others. Well, indeed, are first responders not part of the group of people providing health services? It seems to me it would be included. Well, yes, but those workers are telling us that no. So in terms of respect for their work, we're doing so. Okay, thank you, Ms. Silas. Thank you, Madam Chair. Thank you, Mr. Fortin.
Thank you very much, Madam Chair, and I want to thank all the witnesses for being here today. I think, I hope, I guess, that this process is part of that beginning to change the culture, and that your appearances here today really do help get that message across. And I think, Ms. Donnelly, in particular, I'm glad to see you here today because the technical problems we had before, and I know you're quite frustrated in the attempt to appear. We are in a different room, and it appears to work well. But I think that sending the message to the workers of respect is particularly important, and sending a message to the public is also important. So what I want to talk a little bit more about, because I think everyone will always say, well, the other things cost money. And what we're seeing and what I'm hearing from the witnesses is that the current situation costs the system money. So I'm going to go first to Ms. Donnelly on paramedics. And can you say a bit more about the cost to the system of the prevalence of violence in terms of time off, in terms of retention of employees? How is this impacting the spending for paramedics?
In point of fact, I wish I could give you all the numbers, but we don't have enough research. This area is just emerging, and so as such, we have a lot of anecdotal evidence that people are leaving, that they're burning out, that they're choosing to leave because there is a lot of moral injury, which is this idea that I'm here to help and I'm being abused because I'm showing up to help. But we don't have clear data that say this is the cost of violence, differentiating it from the different kinds of stresses that paramedics are currently experiencing. I did point in my earlier statement to evidence that's correlational between exposure to violence and intent to leave the profession in other disciplines. And hopefully in the next couple of years, I should be able to provide that data for you.
But you would essentially agree that it is a factor that adds extra costs into providing the
100%.
service, right?
100%.
And maybe Ms. Silas, go to you next in terms of nursing, in terms of the costs to the system.
Yeah, I personally didn't bring it, but Danette did talk about it. 30% of workers' compensation claim just on violence. That's just for BC. We see the same thing across the country. Numbers of violence and injury more than doubled in the last 2 years, again from BC. But it is a big cost. And the biggest cost is what Danette was saying. People don't want to go in healthcare. You know, we just spend a day on a Center for Health Human Resource. And our biggest challenge is how do we make healthcare jobs attractive again? And when they hear all of us talk about violence in healthcare, it is not a very attractive way.
Okay, and then Ms. Thompson, you're the one who brought the most specific things to us, so maybe I can turn back to you and allow you to say a bit more about this.
Yeah, thank you, Ms. Silas. Stats Canada's most recent data showed by the end of the third quarter of this year, 2023, that there were 5,825 nurse vacancies in BC. And so that's an increase of the same whole year of last year of 5,300. So I think that in itself, that fact that we're down 500 and 25 nurses, I mean, shows it itself. And I'm telling you, you can look at even our rates of just casual employees. Nurses don't want to work full time. When things are getting ugly, they need to be able to pull off. So it's costing us in many, many ways that are not even measured.
And in terms of services that are made available to employees, in terms of support services like counseling or therapy, are you finding that the increase in violence is accepted as a reason for receiving those support services?
Those support services in BC are so overused that sometimes it's taking our members 6 weeks to get help after they've witnessed a violent incident. You know, we're pushing for critical incident stress debriefing and all of those things that the employer is supposed to be providing. But even that's taking time because the increase of just need for those services.
So the services aren't keeping up with the need for those services. Maybe Ms. Silas, you can comment on that as well.
No, exactly. There's not enough services, and we have to not only to heal these healthcare workers, but we have to prevent. That's the biggest thing we have to do. We have to prevent, and that's with safe staffing, and it is with appropriate security mechanism in all our facilities. And community, Elizabeth.
So, Ms. Silas, would you say that the general understaffing that we see in terms of nursing jobs then makes nurses more vulnerable to the violence on the job?
Have you been in an ER lately, Mr. Garrison? You know, when you wait 18 hours, 12 hours, you lose patience and you're sick. So, yes, of course, there's more backlash.
Right. Okay, thank you, Madam Chair.
Thank you very much. We'll now begin our second round, and we'll ask Mr. Doherty for 5 minutes, please.
Thank you. Thank you, Madam Chair. Thank you to our my colleagues for allowing me to sit in on this today, and thank you to our guests. Ms. Silas, and Danette, 321 came out of our conversations that we had, very honest, very frank conversations earlier on when we were dealing with my bill C2 211 on PTSD, and I have the questions. I have the backgrounder that Mr. Fortin was looking for in the information. I will send that to the committee. I want to take up any more time trying to answer your question, Mr. Fortin. I will get you the information that I have, and I'll send it through my colleague here, because I think what we need to hear more of is the voices of our guests that are here. You know, I spoke to a group of nurses in northern BC 2 years ago at the invitation of Miss Thompson, and I just mentioned this proposal of this bill, and it brought tears to nurses around the room, which and it was a very emotional time. And so through you, Madam Chair, I want to ask my colleague or our guests that are here, why would just talking about this bill, the proposal of this bill, evoke so much emotion with your membership that's there, Ms. Silas?
It's recognizing there's a problem. It's a question of respect. You know, to change the criminal act, the first one with C3, and even a framework on PTSD, we had to talk to our own colleagues who actually didn't believe that a sick patient or an angry patient should be charged, that a nurse should be calling the police. There was a lot of education to be done there. They really thought it was part of our job. And we changed that, and it's with the work with MPs like all of you that we were able to change that. Now we need to do the education on it.
Annette?
Yeah, that's so true. I'm going to say around that table, they're desperate. They're desperate for help. Our nurses are out there and they're giving all they can. They're working in unthinkable sometimes circumstances, but they're there because they care, and they're there because they want to make a difference. So to be recognized for what they're doing and what's happening and how desperate they are for help, that the government would actually say, oh my gosh, like, we see you, and this is not okay, is what sparks the emotion. It sparks the emotion in me. I mean, it's unthinkable. I have a beautiful granddaughter. I think will be a nurse one day, and I hope, she's going to be remarkable. But I don't even want her to be a nurse in these situations and in these circumstances, and that needs to change. That needs to change.
Donnelly?
I want to echo what my colleague said. It's acknowledgement. Like, if you spend so long feeling like this is the way it is, this is what I should expect, this is the level of, violence that I should habituate to, that it becomes background noise. It becomes just part of the business of doing your work. And for someone to say, hey, maybe tolerating abuse isn't an expectation. Maybe you can go to work and not have someone sexually assault you, is identifying. It's saying, hey, we see that this is a problem. We want to talk about it. And then that allows then paramedics, nurses to be like, yes, it is a problem. And these are the ways in which this violence has impacted me. So asking that question is so incredibly powerful. So thank you for asking.
30 seconds. I just want to again thank our guests that are here today, your membership, and the firefighters and the paramedics and all of those who have shared their very emotional stories with me. You can't help but not be impacted by these stories, and I hope we'll do you right by passing 321 hopefully soon, and I know that the industry will share that message. It provides another vehicle to share the message that violence against our healthcare and first responders is not okay, and it's not part of the job description.
Thank you. Thank you very much. Madam Dillon, yes?
Thank you, Madam Chair, and thank you to all of our witnesses for being here and sharing what everyone goes through who works in the healthcare system, and to represent all healthcare workers across Canada, pretty much. And my question is going to be for all three of you. Maybe I'm just going to put all the questions out there, and then one by one you can take your turns. We've seen, the heard your testimony. Very painful to hear, especially when you're serving people at their most vulnerable. You too are at your most vulnerable as well. Could you tell us, please, if the increase in violence has started pre-pandemic or after? Please explain to us why you think there is this surge of violence, how COVID exposed this vulnerability of healthcare workers. And please, I'll let you start with that, and if there's anything else, I'll follow up. Thank you to all of you.
I'll try to be very quick. The first campaign on no to violence in healthcare was in 1991, done by the British Columbia Nurses Union with posters, no to violence. We've come a long way in regards to changing the criminal act. We've come a long way in trying to change the culture, and we still have a long way to go. And that's key. It's a long process because the culture of healthcare is an interesting one, to be polite.
And to our other witnesses on Zoom.
I'm going to be a little wonky, and I hope you'll forgive me. And when you say, is the violence increasing in the paramedic community? We don't know because we don't have the data. We have lots and lots of anecdotal evidence. There's lots of news reports around it. So is violence increasing? Maybe. Is our systems increasingly stretched and we are trying to do more and more with less and less? Absolutely. Are paramedics willing to talk about it more? Because one of my colleagues, Mandy Johnston, stood up and said, it's not okay. Violence is not okay, and developed this entire program of research and this entire intervention strategy that has been able to bring these data to you. So is violence increasing? We don't know right now. What we do know is it's unacceptably high.
Yeah, it's definitely increasing, and but it was a problem long before COVID. And I think that since COVID, we've all seen changes in society that none of us really know. We all have our theories of what's causing those, but honestly, the healthcare system is so stretched, and the wait times, as Linda spoke to, all of those things are adding to it. But there's just a change in society, period. People are walking down the street and assaulting one another. And so those things, what we see outside, are also being reflected inside.
And can you please tell us, with the already existing criminal code provisions, where it comes to violence against healthcare workers being an aggravating factor, how this legislation will build upon that, and if any of the three of you see any distinction with this legislation? Thank you.
Personally, I think it's enhancing C3, and C3 is only 2 years old, so we have to do education on it, and we've been working with the Justice Department on how can we promote it. It has to be talked about.
And the other two witnesses on Zoom, please.
Yeah,
Thank you.
I agree, Linda. Let's have a big campaign and promote that violence will not be tolerated by the government of Canada to our nurses in this country. So, those are the types of things we need to see. I think it is enhancing it. I'm so glad to see our paramedics, like our first responders, being included. We are a team. You can walk into an emergency room in northern BC, and the paramedics are assisting in the emergency room because there's such a shortage. So this needs to include everyone.
And for the last 30 seconds, Ms. Donnelly, you can be as longy as you want.
Well, I would just say that paramedicine specifically sits at this really interesting nexus because we're identified as public safety personnel and first responders, and we're also sort of identified as healthcare professionals. And so that, when we say, does this apply to paramedics? It wasn't clear because sometimes we hang out with fire and police, and sometimes we hang out in the ED because we're helping Danette's very, very worthy colleagues. So when we think about the enhancement of this,
sorry to interrupt. Thank you so much. So we're going to go for the final 2 minutes each. 2 minutes chaque, si c'est possible, Monsieur Fortin.
Mr. Fortin for 2 minutes. Thank you, Madam Chair. I thank you again to all three witnesses that are with us. I can hear you saying how much violence has been increasing since the pandemic, despite the amendments made in 2021, so 2 years ago, to the criminal code. It continues to go up. Now, I am with you. My heart is with you. My spouse is a teacher, and every week there are teachers and assistants who are the victims of violence as well. There seems to be a significant societal problem here. And in education, I don't know how we can better help these people and make them aware of these problems. But on that, I wanted to bring you to my last question through this. What can we do? What are the causes? Why are people becoming more violent with healthcare workers, whatever position they hold, and teachers? What is this phenomenon? One of expectations. If people are waiting too long, perhaps in the hospital, they're waiting for doctors and nurses. I don't know. Is it a mental health problem? You who work in this area, I'd like you to hear you on this. Ms. Silas first. What is the profound cause of this? It's poor staffing levels. We have tried. We had shortages before, but we just don't have enough staff in the units where we need them. So we need to have good ratios between nurses and patients, and we need safe workspaces. The other witnesses, please, quickly.
One of the things we found in our research is that a significant number of the violence reports and a significant number of the assaults do have people who have primarily mental health or substance use concerns identified as their primary problem code. And that points to inadequate services for folks in those situations that are leading them into crisis, which are leading them in interaction with our public safety personnel and our nurses. So we need to spend more time and energy focusing on taking care of those human beings.
Merci.
No, merci beaucoup.
Thank you. Thank you very much.
Thank you very much. And I guess I need to go to make sure that Ms. Thompson gets to get in on that last round here, because I think that's an important question. We've had some important suggestions.
Yeah, I think that it's also the facilities themselves. We have mental health patients being placed for days, sometimes on stretchers underneath busy ER counters, lights on. We don't even have enough beds or enough staff that we actually have mental health patients that are being held longer than actually is even legal in seclusion because there's no bed to move them to. So I think there is a whole system review that needs to be done, and we need safe staffing. In BC, we just landed patient ratios, but they cannot come fast enough. So I think the government needs to look at how are we going to incentivize people to come into the healthcare system? How are we going to help build our own and fix our own? And whether it's nursing, paramedics, or doctors, how are we going to create those within Canada?
And I know we're just about out of time, so let me just thank the witnesses again and for the really strong representation of your members, both in paramedics and nurses, and for making sure that you've got our attention on this. I know you've been working at it a long time. That's not new, but we certainly do appreciate the work you're doing.
Thank you very much to all our witnesses this afternoon. Colleagues, thank you very much. That wraps up the afternoon. Wish everybody a wonderful Thursday, and we'll see you again next Tuesday. Thank you so much.